So the process to amend certain sections of our rules started in 2021. Some of you may remember, someone other than me might have sat up here at a different time and talked about some of the original rules proposals. And some of those were a little controversial. The mandatory mid-case review was originally proposed, where in every bankruptcy case, after 24 to 36 months, we would essentially do a final cure in the middle of the case to make sure all the payments were filed. Additionally, switching from the notice-based final cure to the trustee actually filing a motion and requesting an order on the status of the case at discharge as to the mortgage. There were a lot of comments to those specific proposals. Most people don't. There are a lot of trustees, and it's interesting, especially for Cindy and I, because we meet so many people that do what we do all over the country, and we see a lot of different trustees. So if you just practice here in Southern Illinois, you get a couple trustees, where we see all of them at some point. If anyone has been fortunate enough to attend the NACTT, the NCBJ, you meet a lot of people with a lot of differing opinions. Some of those trustees do not like to file final cure notices at all. So we'll get to that a little later, but certainly having to file another one in the middle of the case was not something that the vast majority of trustees were interested in doing. So the Rules Committee got all these comments and decided that they would make this a not mandatory process where the debtor or trustee could do so. But the result was that they had to republish these rules. The comment period for this particular set of rules expired in February 16th, 2024. So basically, for us, your mortgage servicers, there are 4 major rule changes that we're dealing with. The first kind of remedies an issue that we've had for quite some time about reverse mortgages and whether they actually apply to 3002.1. The language, as currently written, says this rule applies in a Chapter 13 case to a claim that is secured by a security interest in the debtor's principal residence and for which the plan provides for the trustee or debtors to make contractual installment payments. Now, as a reverse mortgage, there are certainly no installment payments made. So the change that the committee has made is they have stricken the word installment from the definition. So, and the committee note that they wrote actually reads, subdivision A, which describes the rules of applicability, is amended to delete the word installment in the phrase contractual installment payment in order to clarify the rules applicability to reverse mortgages, which are not paid in installments, which is great. So now it reads contractual payments. And what exactly contractual payments are we making on a reverse mortgage? I do not know the answer to that question. So I believe they have done pretty much nothing other than what the subdivision says. So maybe you can argue that taxes and insurance, if they are escrowed and paid, but yes, those are being paid, but they're not being paid to the servicer. In most cases, you're not escrowing a reverse mortgage. So yes, there are payments being made. The trustee may pay the taxing authority or the insurance company, but a lot of times that money's not going to go to the servicer. And this still applies only to a principal residence. So you're not getting these notices of fees and costs and charges, et cetera, pay changes on what if it's an income producing property that is necessary for an effective reorganization. So perhaps they have a couple rental properties and that's what's funding the plan. Under this provision and the amended one, those notices do not have to be filed. So you're not going to know the status, or you're not going to know what has been assessed against those properties. So in the comment period that recently closed, there were lots of comments about saying, why are we not filing these on all real property? What is the distinction with the debtor's principal residence? Obviously, that's where they live and most important to them in most cases, but it's not like disclosing this information would be a bad thing. So it will be interesting to see if the committee takes that to heart, because there were quite a few comments that reference that. In addition, since they are making contractual payments, what about a cram down? Those are no longer contractual payments because they certainly aren't made pursuant to the note or claims that mature during the case. Those aren't contractual payments. I mean, they're monthly payments made by the trustee, but they're not contractual according to the note. So I think by removing one more word, they can solve all those problems. Perhaps we're going to file a lot more, but that's fine. So,
Well, and let me just add this, because I've had this happen in my own practice where the trustee is paying on rental property, and if there's an adjustable rate or there's an escrow change, how does she know to make a different payment if there's no notice filed, right? I mean, presumably the homeowner, the debtor, might get a notice from the creditor, but they're not sending that to Diana.
that's correct. That
Or
would have
you.
been
Or me.
would have been a really good comment to make, David. Not to me, but to the federal rules.
Well, I was there, but I wasn't allowed to speak.
Right.
No.
Well,
There you go.
that's why the comment period is open, but now closed. So if it reopens, I'll let you know. So anyway, but there were a lot of comments similarly along that vein, and it's an excellent point. It's not just the principal residence where this creates issues for people. So I personally.
It also creates inconsistency in how our clients deal with all of their loans. They would like to have some consistency with regard to should a notice be filed. So you'll have some of them that say, we'll do it on every single loan, and others that are very particular about when those notices are sent because they feel as if the rule is specific. Filing it when it doesn't apply maybe exposes them to certain liability that they wouldn't have if they don't file it. So some uniformity would certainly be beneficial.
Let me go ahead and cross off my next
Oh, so
section.
sorry.
Oh.
It was not my turn to talk.
No, that's fine. But that is right. There are some districts that will actually sanction a servicer if they file one of these notices when they are not required. So, and I'm sure there are people in the audience that if I file these notices and then perhaps also file a fee request for doing so, that may draw an objection because they are not required, even though the information is good to have. So it would be very nice to clean up all of that and say, file all of them. We'll see if we get there. So that's part one. Part two, and this is very interesting because David and I had this issue come up Tuesday. So pay change notices. There's also some amendments to the pay change notices. The big one addresses HELOCs. There is not a specific exemption for HELOCs. You can file the motion asking to be excused from having to do so. But I don't know about everyone in the audience or you if you're going to be filing those motions for free. I am not. So we don't get a lot of those. So what I'm sure all of you see if you have a junior or another home equity line of credit or some sort of adjustable rate mortgage, what do you get? Pay change notices every month. Every single month, like clockwork, you get that notice. So the proposal has an amendment, which I think is actually great. So the new language provides an option to provide an annual notice with a reconciliation as long as the payment change is less than $10 in any month. So this will eliminate the monthly requirement to file pay change notice. Obviously, those were very burdensome. So once a year, you file your notice, whatever the debtor paid, maybe they owe $15 combined, or maybe, they have a $15 credit, you do a reconciliation that way, you give them what the payment will be moving forward, and you only get one a year, just like every other lien. So that would be delightful. We'll see if that passes. There were most comments that were filed about this particular section were great. But that's not all about pay change notices. There has been a lot of confusion as to when a late filed notice is effective. So the proposal here says if a pay change notice is filed late, the next payment, the one that is effective, is the one that is more than 21 days after that notice is filed. So as an example, let's say that my client files a pay change notice in Kim's case today. and it was supposed to be for April. Well, that's not 21 days notice, so that is not effective. So that will go into effect for the May payment, and that is codified in the new rule. If the payment goes up, if the payment had, for whatever reason, gone down, it is effective for the next payment. So in my example, if the payment goes down, that payment change is effective for April. If it goes up, it's effective for May. So I think that makes sense. If the servicer is to blame for the notice being filed late, and the debtor should still get the benefit of the changing rate. If it's in their favor, with a short notice, they should not be required to pay that extra amount shortly. So I don't really have an issue with that. Next, we have the all-new motion to determine status under 3002.1F, which is now optional. At any time after the case is filed, this is all new, before the trustee's end of case notice. That's a foreshadowing to the last rule change, by the way, because we don't have final cure anymore. We have trustee's end of case notice. So I'm sure there'll be an anagram for that, like NOFC. The debtor or the trustee may file a motion to determine status of any claim described in 3002.1A. So my favorite thing of all of this is there are forms, lots and lots of forms involved with this. So the motion to determine status, that is form 410C13-M1. So the trustee or the debtor has to use that form, which basically says, filing a motion, want to know what the status is. If the creditor disagrees with this information, must respond within 21 days using form 410C13-M1R, which is very similar to the 410A proof of claim attachment. So it's basically the same type of process. We're showing the whole status of the case on that type of form. So at that point, the notice and hearing are held to determine the current status of the claim and enter an appropriate order. And that's, of course, what Judge Surratt states we'll be doing. So the big issue for us relating to that is there is no limit to the amount of times that the trustee, who I don't expect to file many, certainly in this district, and the debtor can file these. They will be a giant pain in the neck to do. This is basically like coming up with a full case motion for a leave pay history. I believe that there has been a tremendous amount of disclosure. The trustee's making the payment. Certainly you can see every payment that has been made to my client by pulling up the trustee ledger. You are getting monthly statements in bankruptcy, which reflect quite accurately what payments have been made. This is not a gotcha situation anymore. I think that the courts and the trustee and your attorneys, my attorneys, we have come a very long way since back in the dark ages when you'd file a proof of claim and there would be a $6,000 charge labeled other or bankruptcy fee or advance. So when you're looking at the proof of claim, when you're looking at the statements, it's very helpful to have all that information. I'm sure I see many faces here that were practicing when I started practicing. How many objections to claim did we used to do? I mean, every other claim was objected to because I don't know what that is. And then you do that whole process before or after the claim is filed. Now it's just all out there before. Certainly we see some of them, but nothing like we used to. So that will be interesting to see how often that process is used. If you do have a very complicated case or something went sideways and you just want to be sure, it will be a tool in your toolkit to use. So, and the last one, I went longer than I said I would. Shock.
That's okay.
Right. Is the all new, but still roughly the same, trustees end of case notice of payments made. Instead of 3002.1G, this will be 3002.1F, or vice versa. Will now become G. That other mid-case thing is F. This replaces the final cure payment procedure. So, interestingly enough, they changed the language here from the trustee shall do this, for the trustee must do this. So I don't know the difference between shall and must. I think the committee thinks that those trustees that have no interest in doing this at all are gonna be, yes, Your Honor.
The change from shall to must doesn't have any meaning because all of the bankruptcy rules are being restyled effective, I believe, this year, and all shalls in the rules across the board.
There you go. So this is a stylistic change.
Ahead of the game.
I have this funny feeling that the trustees out in North Dakota that do not appreciate this will not interpret that any differently than they have been doing before.
Can.
So we will see. So the difference being, the timing's a little different for the trustee. They have to file this end of case notice within 45 days of the completion of plan payments by the debtor. So before it was the last payment made on the claim. So you might get some of these very early in the case. We didn't necessarily do it that way, but there were lots of districts that did. So, and the trustee basically has to say what's paid to the claim holder, whether any pre-petition default has been cured. Guess what? More forms. This is a prescribed form now. It is 410 C13-N. These are my favorite forms right here. The response deadline is graciously extended to 28 days for creditors to respond from the 21 it was previously, and the creditor must respond on Form 410 C13-NR. After that deadline expires, or after Form 410 C13-NR is filed, the trustee or debtor may file a motion to determine whether the defaults have been cured and post-petition payments have been made, and guess what? That response is to be made on Form 410 C13-M2. And the creditor must respond to that motion, this time within 21 days again, using Form 410 C13-M2R. I suppose AI is coming for all of us with these notices. We shall see if we are still needed to practice law in this procedure in the next decade or so. Cool. Then the court sets a hearing to determine the status. So those are the four big changes that we are monitoring. Again, December 1, 2025. If the Rules Committee makes any substantial changes, they will have to republish, which will push this out further in the future. And whoever sits here next year, which I certainly don't mind doing it, but we'll tell you what those days will be. So, and that's the rules.
Excellent. So I'm going to talk about loss mitigation. It was 4 years ago last week that we went on lockdown for COVID. Seems some days like yesterday and some days like an eternity ago. But loss mit came into the forefront as soon as COVID hit, and we had lots of different options that were available to us, some government mandated and others just brought on by the industry out of clear necessity. So I'm going to start with SAFER, half funds, and then work to loss mitigation as it has always existed. Loss mitigation is the curing of a default. That's all that it is. So a foreclosure is a curing of a default. Back in the day when we had problems with values on properties, short sales were loss mitigation, so is a deed in lieu. But that's not what we're dealing with today. Most people that we see in loss mitigation are truly interested in keeping their home. So half funds, which was the national program distributed, funds distributed from the government, but then made part of the responsibility of each of the states, which meant separate rules for each of the states in terms of forms, qualifying information, and then dollar amounts that could also be available to an individual were designated individually by each of the states. So the SAFER program is Missouri's program, which is state assistance for housing relief. It had, at its start, approximately $125 million that it could disperse to homeowners in Missouri, and in order to qualify, it had to be the principal residence, or still has to be, we'll talk about numbers in a second, has to be the principal residence. It has to be a property located here in Missouri, and then there are certain individual qualifications for the homeowner. They have to occupy the property, again, as their principal residence, have household income equal to or less than 150% of median income, and it has to be a conforming loan. So it was conforming at the time of its origination. As you know, Fannie and Freddie set limits for individual mortgages. That's what makes it a conforming mortgage under those limitations. But the owner also has to have experienced a financial hardship as a result of COVID. So the significance of my 4-year reference is that there is still money available in the SAFER accounts today, and people are still qualifying. As a matter of fact, the qualifications by week, I want to make sure that I get this right, it's about $1.7 million that is being distributed on a weekly basis. However, last week's numbers were at almost $3.4 million. So the money that is left is less than $9 million. So we are running out of money quickly. I believe that because I'm terrible at math, I believe that on those averages, we have about 5.5 weeks left of money available. Maybe less. Again, if we keep running at a $3.4 million run. So obviously there were issues for us in bankruptcy dealing with SAFER funds. And those had to do initially with what do we do? Do we need to have bankruptcy court approval in order to receive funds? From both the debtor's perspective as well as our clients started to receive state assistance monies and said, well, can I apply this? These are monies that are intended to bring the account contractually current. That was the purpose behind all of the money, regardless of bankruptcy or non-bankruptcy status. So if the client is receiving, the mortgage company is receiving monies that bring an account current, but the case is in an active Chapter 13, they are applying funds to pre-petition amounts that are due, that are being paid by the trustee's office. Not only are there significant timing issues that are created, obviously with the request for reinstatement figures, many of our clients will not issue figures beyond 14 days into the future. And the reason for that is that those numbers are changing constantly. There can be advances, there can be fees, there can be disbursements that are being made during that period of time. And as a result, they try to shore up those figures and make them as accurate as possible. So if a request is being made for reinstatement figures, the debtor is turning those numbers over to SAFER, and that time frame is taking 30, 60, 90 days in order to process. Well, those numbers have changed. So you all saw lots of motions for relief, objections to confirmation that were continuing out over and over again in order to allow funds to be received and to be applied. But then you were hearing from me and Dan about the fact that these monies were going to be applied contractually, and we needed some court assistance to make the determination as to whether or not that was available to us in a Chapter 13 setting where monies received post-petition should only be applied to post-petition amounts that are due. I think we worked wonderfully here in this district to be able to resolve a lot of those issues pretty early on. And as Dan indicated earlier, as we travel and have discussions with our colleagues, not so simple in other parts of the country, so we are certainly lucky here, and we know that to be true. But the question has always come back to us, what can debtors' attorneys do to help us help you and have your client get the money available to them? Work with them on the applications. What we often heard from our clients is that they would send out a reinstatement quote, they would be communicating with the agency, and then hear nothing. And status would show that documentation was missing, that they hadn't received everything that they needed from the borrower. As the numbers continue to grow, there are limitations with respect to the amount of monies that can be dispersed. Obtain court approval. If my client is asking for court approval, please ask the court for the necessary approval so that it can move forward. And then object to my proof of claim if it hasn't been amended quickly enough once those funds are applied, and also file an amended plan to address those issues as well. HAF did not cover second mortgages, balloon mortgage payments, payments of principal reduction on completed loan mods or partial claims, and we'll talk about partial claims in a minute, or pay delinquent property taxes prior to January 1 of 2020. Okay? Questions about that? I feel like we all know enough about HAF. Yeah?
Yeah.
Thank you. Okay?
Second mortgages, no. HELOCs, no.
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 Nope.
No, no,
No.
and no. Okay, so loss mitigation in general. If your client applies for loss mitigation with a servicer, understand that, and you all know this, there is a significant amount of financial information that they are looking for from your clients. Be involved in the process to know what documentation they're asking for, but your clients have to drive this train because there is, a significant amount of information. Each of them will go through what our industry calls a waterfall to determine where they are eligible for a loss mitigation program. First and foremost, if they can reinstate the account, that is the expectation. If they have funds available to them to bring the account current, reinstatement is the first step in any sort of waterfall consideration. Forbearance, which became the princess of COVID and the nemesis of Dan and I for spelling purposes, forbearance
make sense.
without an E,
Makes no
foreclosure
sense.
with an E. We both struggled. But forbearance, simply pushing off the lender's rights with respect to a default. So we all thought of it as the borrower doesn't have to pay during this period of time. That's true. That's true. Maybe. But truly a forbearance is just the mortgage company indicating that it will not exercise its rights with regard to a default during a period of time. As we found out quickly, forbearance payments become due as soon as that forbearance period has expired, and a default immediately exists as soon as that period expires. So that's then when many people began to panic about what do we do next. Deferral became a major player in COVID forbearance resolution by taking a portion or all of the missed payments and putting them at the end of the loan. That particular portion would be due either when the loan was refinanced or the property was sold. Some of the deferrals, COVID deferrals specifically, are non-interest bearing deferrals. But again, a deferral has always existed as a loss mitigation option. Loan modification, this is the one we've always used and known about and was most popular after the crisis in 2008. And that is an agreement that changes the terms of the mortgage and the underlying promissory note. Most often, it is changing interest rates, hopefully by reducing them. It is changing interest rates by making them fixed rates when they are otherwise adjustable, recapitalizing missed payments, and oftentimes extending the term of the loan. But what we have today are interest rates that are drastically higher than what most people who either just before COVID or even as COVID started were able to refinance debt to interest rates less than 3%. So at today's rates, a loan modification to recapitalize amounts that are due just aren't a viable option for most people, and certainly are not the avenue to reduce an ongoing payment.
Well, and don't forget, it also re-amortizes the loan, which means your client's going to have to pay all that interest again. So I know you're okay with that,
I'm
right?
okay with
But
that.
I don't like it.
That's kind of how it works. Right.
Interest, also known as income. That's correct. Yes, that is correct. So then came partial claims. Partial claims are available from HUD and VA, and they are an important tool in the environment that we're in today, where we're talking about high interest rates, but also high values on properties. And the basic premise of this option is to take 30% of the unpaid principal balance of the mortgage. That becomes the source of funds to offset the arrearages that exist, okay? Keep in mind, these are for FHA and VA loans. So we've talked previously in other discussions that we've had about know your mortgage. You can find the type of loan that your client has on the Fannie Mae website, on the Freddie Mac website. FHA loans have an FHA number on the deed of trust themselves, and so does the VA specifically reference that it is a VA loan. So knowing your loan here is important. Some of the servicers have done something equivalent to the partial claim, but what you're finding is it is the insurer, FHA, VA, that is funding this particular 30%. What results from the payment of that 30%, up to 30%, mind you, is a second mortgage on the property. This has all of us, from a bankruptcy perspective, halting, because we know that what we're doing at this point in time in order to fully effectuate a partial claim is recording a lien against property with the automatic stay in effect. So the significance of these, I say more so even than the loan modifications, which this district has always expected court approval for, the partial claim absolutely needs to have court approval to allow for the actual recording of the document. It's important to understand that even if the loan is an FHA or a VA loan, because of this cap regarding the percentage, not all loans are going to qualify for a partial claim. And it also is something that we just have to be careful about, because as these values, we continue to have values that are very high, but as these values decline, we end up in a particular difficult situation. I think I'm starting to eat into some of your time.
You take it.
David.
Just take it. I'm good with it.
Questions about loss mitigation or options available? Okay.
Oh, boy.
All you, David.
I got the whole 20 minutes, huh?
You sure
I'll see
do.
if I can use it. I'll tell you, I, for one, will not be sad to see Safer run out of money, and I know you're probably surprised to hear
Coming in hot.
me say that as a debtor's attorney, but I have clients that are discriminated against in housing, and they can't find places to rent. And then here, the government is just throwing all of this money at people who may or may not have been out of work. It just doesn't seem right to me, you know? Also, I think it negatively affects our practice, just the same way as loan mods affect your foreclosure practice. It's made this game a little harder, so.
Well, it is interesting. Proof of hardship. This is from the SAFER website. We will need a description of the nature of the financial hardship. For example, job loss, reduction in income, or increased cost of healthcare or housing-related expenses. That's my COVID.
I got COVID and I missed some work.
There you go.
You know?
I think you and I might have qualified.
We would have qualified for that.
While Cindy was talking, I pulled up the website that you relayed all your figures from, down even less. And between Jefferson County, St. Louis City, St. Louis County, and St. Charles County, 8,000, wait, no, that's total in Missouri, almost 4,000 awards in those counties, the 4 counties that we mainly practice in. So if you think about where those 4,000 homeowners would have ended up, either with us or with you at
Or
some
both.
point, right, or both, because if they end up with us, they could very well end up with you. So I hate to be overly optimistic, but as this fund does run out and there is no longer a safety net for those that aren't fulfilling their obligations pursuant to the note that they signed, we may start to get a little busier.
Well, and I wish I could agree with Dan. I think that the government and the GSEs, Fannie and Freddie, continue to look at, we'll call them creative ways to resolve continued defaults. I was reviewing pleadings the other day with 2 and 3 partial claims having been given on individual properties. At some point in time,
You have to pay your house.
we have to let go.
I'm sure that's going to happen in this election year.
Certainly not in
Right.
2024. Definitely not.
So maybe next spring we'll see that increase in volume.
Correct.
Well, one thing I wanted to just announce, not really talk about, but just let you all know, the Consumer Bar is going to be pushing for a rule change this year to allow mortgage arrears to be paid over the life of the plan and get rid of this 48-month nonsense that we've been living with. I've talked.
We will kick and scream.
I have
But-
talked to several
Cheers.
prominent creditor attorneys, and they have told me they're not going to fight on that hill. But
I
I'm
don't
curious
know
what
who
you
those
guys think. No, just kidding. Just
So-
kidding. I've talked to both of you.
So here's the delightful thing about that, and I think we've been very fortunate, but many times when we tell our clients, no, the arrears have to be paid in 48 months, they're like, what?
Where?
Why?
Why?
That doesn't make any sense.
Why would you do that?
I don't even know how to put that in my system, because all over the country, it is paid through the plan. So it is very unusual. We are very unusual to have that in place.
Well, it's going to help your clients with a lower 13 payment, or if you're like me, what I do is I calculate my payment over 60 months, right, so that they get a lower payment. But then that bites me because my 3.6 attorney fees are pushed to oblivion, you know. So I think it's going to be very helpful. I'm hoping that the creditor bar is okay with it. Happy to hear what you guys both said, and ultimately it'll be up to the judges and the local rules committee, but that is something that we're going to work on this year. All right, so I also want to talk about projected escrow shortage. What is it? The mostly settled law of mortgage cram down and the profound holding of in re gets. So I got a few things here, like a little buffet. So projected escrow shortage. What is it? Well, 12 CFR section 1024.17, which is the consumer protection regulation, allows creditors to have a 2-month equity cushion, right? And that went into effect in 2011. At some point a few years ago, I started seeing on the form this projected escrow shortage. And I'm like, what is that? And I would have clients that were not behind on their house, okay, 0 arrears, okay, and then there would be a claim for several $1,000s filed. And I'm like, okay, is this a claim estimate? Because it's a projected shortage, and do we pay estimated claims in bankruptcy? No. I objected to one. Cindy was on the other side of that, and she told me, she said, David, you do not want to do this. This helps your client. I'm like, yeah, well, I'm doing it, right?
That's exactly how that went.
I'm doing it, and then Judge Shermer said, no, you're not, right? So that got shot down. We will pay estimated claims. So I'm thinking here, okay, mortgage companies, they're pretty good, but they make mistakes. They make accounting errors. I'd say 1 out of 100 motions for relief has probably got some errors in it. So it's been my experience. It's not that common, but it happens. And so I'm like, okay, how on earth are these mortgage companies going to reconcile the money that Diana is paying them, for arrears and corporate advances and all this other stuff with the escrow account? There's just no way, right? There's no way they can do this. Well, I pulled a few examples, so we'll go over them. So the first example, Freedom Mortgage. Case was filed November 22nd, 2022. Proof of claim for $0 arrears, but the projected escrow shortage was $843.35, which was exactly 2 months of the escrow. Wow, go figure. So first notice of payment change was filed on November 1st, 2023, and guess what happened? The escrow went down, $92.98. I was not expecting to see that. It was just the other day. I was like, wow, okay, maybe there's something going on here. And then there was a second one filed in April 1st of this year. It only increased the escrow by $37.29. All right, that's pretty cool. All right, Rocket Mortgage, okay, case was filed on July 5th, 2022. Also, no arrears was in the plan, but somehow the mortgage company disagreed with me and said, hey, you know what, I think you're one behind. All right. And then also a 2-month escrow cushion was filed. Now, on this first notice of payment change, which was just a few months later, April 1st, 2023, so I guess almost a year, the escrow increased by $116. So I'm like, okay, well, maybe that's not good. But, you got to think, well, how much of a difference is $571 paid over 48 months by the trustee really going to affect the escrow account? So there's all kinds of factors at play here. And there's really no way of knowing, but in this particular instance, it doesn't seem like it helped anything. Third example, Rushmore. Now, in this case, the debtor was $135,000 behind. And also, on all three of these examples, by the way, no motions for relief have been filed in the case. No motions to dismiss. Okay, so we'll put that out there. But yeah, this guy's really far behind, but somehow he's making it work. Well, all right. So then this particular claim, the projected escrow shortage was 4 times the amount, which I guess I probably should have objected to that, right? But I don't know, I missed it. Well, and then first notice of payment change, it only increased the payment by $74.81, and the property value had increased in that time period by $88,000. So I'm like, okay, well, you know what? Maybe this is making a difference. Maybe Cindy was right. Maybe these are in my client's best interests. I don't know. I think the jury's still out on that, but
well, the alternative is to pay that portion within a 12-month period of time.
That's right.
Or pay it over 48 months.
Or just don't put the cushion in to begin with.
Now,
I mean,
hold tight. So the
well, I got you on this one, didn't I?
No, you did not. I get a
little flustered.
I get a little anxious when it comes to escrow, because escrow is something that the vast majority of people simply don't understand. If you receive an escrow statement, you can do everything that David has just talked about here by looking at the statement itself, okay? It is going to tell you, escrow is taxes and insurance, and sometimes for your clients, mortgage insurance. But that's all laid out within the escrow analysis itself. It provides the dollar amount you said estimated claims. Every single escrow statement is a projection into the future. It is anticipating what will happen in the future because these are amounts that are being collected on a monthly basis and then sometime within the next 12 months being dispersed by the mortgage company on behalf of your client and themselves to protect their lien interest, okay? But the dollar amount for taxes is laid out as an estimate based off of the prior year's tax amount. The insurance is laid out as a dollar amount based off of last year's actual advance with regard to insurance, and then the same holds true for mortgage insurance where applicable. That number is then divided by 12. Then there is a cushion that is built into every single escrow analysis, which RESPA allows. But the issue becomes, when a bankruptcy case is filed, it's about the timing of disbursements that are going to happen. If your client hasn't made payments for, I don't know, $135,000, there are a lot of advances that have been made. There are $0 that are in the escrow account, and yet our clients are responsible for making those disbursements still as time goes on. So we have to fund an escrow account based off of the timing of those disbursements. If you have filed in October and taxes are due in November 1st, delinquent December 31st, and those monies are going to be paid, well, that's only 2 months of funding. That creates an automatic deficiency in that escrow account, and your projected escrow comes from the difference between the funding and your lowest point in escrow. So to the extent that I've taken up too much of David's time already, but to the extent that you end up with an escrow analysis that you have questions about, I am happy to walk anybody through an escrow analysis because quite candidly, it saves us a significant amount of time if you understand escrow.
Yeah, I'm not happy to do that.
That's
And
why you all
call
have to
Cindy. In fact, what I would like everybody to do is go on the court's website and watch the YouTube video of her telling that, because that was very well done. And
Well, I think nothing's more offensive to a foreclosure attorney than saying that the debtor is $135,000 behind, right?
Seems like we
Thank you,
should have been able to
COVID,
do our
for
job
mortgage
in there
forbearance,
somewhere.
right? All right, well, briefly on mortgage cramdown, I think this is relevant as a current issue because back in the late 90s and early 2000s, there was some creative lending practices, as we all know, and there were a lot of these 80-20 loans that were originated. So you have a lot of second mortgages that were 360 months and they're going to start coming due in the near future. So mortgage cramdown is the exception to the exception, right? So in bankruptcy, we modify claims. That's what we do, except not when it's your house, not where it's where you live. We don't do that. And the Supreme Court said that in Nobleman, which was a 1993 case that basically reconciled the tension that was between 506A and 1322B2. So we can't mess with mortgages except that we can cure them, except unless we can. And so what happened, the history behind 1322C2, there were two Third Circuit cases that were that came out. The first one was Matter of Roach, which was 824 Federal 2nd, 1370, Third Circuit, 1987. And in that case, the debtors were not able to reorganize on their house after there had been a foreclosure judgment. The house hadn't been sold yet, but it was initial foreclosure and there was a judgment of foreclosure. So then in direct response to that, we get 1322C1, which says, hey, if the property hasn't been sold, you can still reorganize. The second case was First National Fidelity Corp versus Perry, which is 945 Federal 2nd 61, Third Circuit, 1991. In that case, the debtors were unable to reorganize in 13 after a mortgage had been accelerated. The court ruled that the creditor was entitled to immediate full payment and you couldn't modify that with bankruptcy. And that's where we get 1322C2. And in fact, the legislative history behind that statute, 1322C2, it period for curing default relating to principal residence. Where's the cram down in that? So we get this case out of the Fourth Circuit called In Re Witt, which is 113 Federal 3rd 508, Fourth Circuit in 1997. In that case, there was a 10-year balloon, and the creditor successfully argued that 1322C modifies the payment structure, not the claim itself. Okay, so what that means is that the debtor could cure the arrears over the 60 months, but they had to pay the full amount. They couldn't bifurcate it. In other words, if your house is worth $10,000 and the mortgage is $50,000, then and if it's a fully matured, or if it matures during the life of the plan, rather. Maybe I should read the statute here and give you guys some context. Notwithstanding Section B2 and applicable non-bankruptcy law, in a case in which the last payment on the original payment schedule for a claim secured only by a security interest in real property, that is the debtor's principal residence, is due before the date on which the final payment under the plan is due, the plan may provide for payment of the claim as modified pursuant to 1325A5 of this title. Okay, so that was the issue is, are we just modifying the payment or are we modifying the claim? And the Fourth Circuit said, you know what, we think we're modifying the payment. We couldn't bifurcate that. Well, that ended up being a bit of an outlier of a case. And there were a lot of cases that rejected WIT, including the Fourth Circuit itself, because that case was overturned back in 2019. Okay, so why is this relevant? Well, there was just a case last year, or I'm sorry, in 2022 in Re Harris in Wisconsin, where the mortgage company was trying to make that argument. And there's actually no controlling precedent in the Eighth Circuit on this. Okay, so, I mean, technically it's still in play. If you wanted to give it a shot, I welcome you. But I want to read a quote out of this. I love this quote. This is what the Wisconsin court said in determining that you could bifurcate mortgages that were maturing during the plan. Looking at the plain language of 1322C2, the court is not persuaded by Deutsche Bank's reading that modification relates to payment of a claim. The structure of the text supports the debtor's argument that as modified refers to the claim. Such a reading comports with the grammatical rule of the last antecedent, i.e. that a phrase should modify its immediate antecedent. Here, the phrase as modified should be read as modifying the word claim and the immediate, which is its immediate antecedent. Wow, it's like wordsmithery, right? I really enjoyed that. Okay, so just some practical, yeah, I'm a little bit of a nerd when it comes to that, I guess, but
A little bit.
practical points though, okay? And this is also relevant in income producing properties as well. I had a case last year, we had 5 mortgages that we crammed down. But for practical points, get an appraisal before you file the case. They are really important. Don't assume that the value that your client is telling you is going to hold up. And I have actually found the creditor bar in this jurisdiction is very reasonable. Mortgage companies, I don't think they like to fight losing battles. So if they see your appraisal, I think it can be persuasive. And I've had a lot of these instances where they just haven't chose to fight us on it. Which is really good, because if you have an evidentiary hearing on this matter and you're on a flat fee, yeah, you're not getting paid for all that work, right? So it's always good to have it all lined up. Okay.
The right type of appraisal, though, right, David?
Yeah, they're all right, as long as the number is good, right?
Income producing versus valuation becomes important.
Yeah.
Yeah.
I don't think I have time to talk about GETS.
We have about 1 minute left. So.
Well, GETS is a really important case, and it really isn't a mortgage case, but it just says that post-petition, pre-conversion equity is property of the estate, okay? And if you're doing a lot of 7s with houses, then you probably shouldn't be practicing bankruptcy. But what I do see all the time are debtors who are in 13s. The trustee pays off the car. There's even a lien release that's issued, and then we convert the case, and then the 7 trustees like, yeah, nothing to see here. Well, I think if you read GETS, that car's in jeopardy now under that holding, right? So it's not just the equity appreciation of the asset itself, but it's also the depreciation of the loan that the trustee's paying on. It's all property of the estate, right? Indivisible under section 541.